Welcome back to Putting the Pieces Together, Healthcare Compliance Simplified. I'm your host, Angela Guerrero, and today we're tackling a topic that's essential for all healthcare staff: service animals in healthcare. Service animals play a critical role in assisting individuals with disabilities, but for healthcare workers, the rules can be a bit tricky. What animals actually qualify? What can you legally ask? And what happens if we get it wrong? To help us navigate this, we have Kristine Tomzik with us today. Kristine is Baptist's Section 1557 Coordinator and Director of Compliance Program Operations. She's our go-to expert on patient rights, compliance, and legal protections. Kristine, welcome to the show.
Hey, Angela, thanks for having me. This is such an important conversation. There's a lot of confusion around service animals, especially in healthcare. And unfortunately, if we get it wrong, the consequences can be very serious. So I'm excited to help break it all down today.
Absolutely. Let's start with the basics. Kristine, what actually qualifies as a service animal and what doesn't?
This is a great question. A service animal is defined under the ADA in the state of Florida disability laws as an animal that is not a pet, is a working animal trained to do work or tasks related to the individual's disability, and may include guiding an individual who is visually impaired or blind, alerting an individual who is deaf or hard of hearing, assisting with mobility, alerting and protecting a person having a seizure, alerting and protecting a person with diabetes having high or low blood sugar, reminding a person who has behavioral disorders to take their medications, or calming an individual with post-traumatic stress disorder during an anxiety attack. An emotional support animal is defined as the crime deterrent effect of the animal's presence and the provision of emotional support, well-being, comfort, or companionship, and may be a pet. But this does not meet the definition of a service animal and is not protected by the ADA or the state of Florida.
That's a really important distinction, and I'm sure a lot of staff have encountered patients with emotional support animals and assume they have the same rights.
Exactly, and it's a common misunderstanding. And again, it can put healthcare workers in a very tough position if they don't know the difference.
So let's say a patient walks in with an animal. How do staff know whether it's a legitimate service animal?
If a patient presents with a service animal, which is either a dog or a miniature horse, there are only two questions that we can legally ask that patient. Number one, is the service animal required because of a disability? And number two, what work or tasks has the service animal been trained to perform? Staff cannot ask any more questions than that. They can't ask about the disability, have the service animal demonstrate the work or tasks that they perform, ask the patient to produce any type of documentation proving that the animal has received specialized training, certification, or licensure, or ask the patient to have the animal wear something that identifies it as a service animal.
I imagine some staff feel awkward or unsure in these situations. So what's your advice for how they should approach these conversations?
My advice is keep it simple and professional. Stick to the two questions and document the responses. There is no need to debate or dig any further. If an issue arises later, your documentation will be key.
Okay, let's talk about where service animals are allowed. Kristine, can they go anywhere in the hospital?
Almost anywhere. Service animals must be allowed to go anywhere where the public can go. Waiting rooms, patient rooms, even the cafeterias. But there are exceptions, like operating rooms or sterile and aseptic environments or isolation units where they could pose a risk to infection control.
And if a service animal can't enter an area, what are our obligations to the patient?
Another great question. If the service animal must be separated from the patient, we have the obligation to ensure the patient gets the care. This may mean that we have to make reasonable accommodations, like bringing a patient to a different area or adjusting the procedure if possible.
Now, this is a big one. When can a service animal actually be removed from a healthcare setting?
There are really two valid reasons why a service animal can be removed. Service animals by law need to be under the control of the patient at all times. If the animal gets out of control and the patient cannot bring it back under control, we can ask to have the service dog removed. What they mean by out of control is an animal that is barking excessively, jumping on people, growling, snarling, lunging, biting, and the owner isn't able to correct it or has a threatening posture that may pose danger and harm the patient as well as others around it. The second reason we can have a service dog removed is if the animal isn't housebroken and is soiling the environment. That's it. Allergies and fear are not valid reasons to remove a service animal.
That's important to clarify. I'm sure staff have faced situations where someone complains about allergies or a fear of dogs, but that doesn't override the rights of a patient with a service animal, right?
Exactly. In those cases, we try to accommodate both individuals, but we cannot deny a service just because someone is uncomfortable.
Another question I hear a lot is, are healthcare staff responsible for caring for a service animal?
Absolutely not. The patient is fully responsible for feeding, walking, and caring for their service animal. If the patient cannot do that, then we have to give them an ample opportunity to find other arrangements, whether that be somebody else to come in and care for the dog or find another option for the care. Staff can assist in finding options like boarding or finding a rescue shelter that may have foster caregivers who can care for the service animal while the patient is in the hospital, but we are not required to take on their care ourselves. Service animals can be very expensive, and we don't want to be liable for any injuries or harm that would come to that animal. Another question I get about boarding and sheltering is that is at the patient's expense. That is not at the hospital's expense.
Okay, good to know. Let's talk consequences. Kristi, what happens if healthcare staff or an organization mishandles a service animal situation?
The risks are very serious. Under the ADA, organizations can be fined or even excluded from the Medicare and or Medicaid programs for significant violations. They can also be sued. Florida law takes it further. Not only can organizations be fined, but staff can be fined too. They may be charged with a second-degree misdemeanor or even serve jail time for denying access to a legitimate service animal.
Wow, that's a big deal. So if there's any doubt, staff should always document the situation, right?
Absolutely. Documentation is the best defense. If there's a complaint, your notes are critical regarding the patient's responses, the situations, and any decisions that were made regarding the service animal.
All right, let's recap. Today we've covered the top things healthcare staff need to know about service animals, including only dogs and miniature horses qualify as service animals under the law. You can only ask 2 questions. Is the animal required due to a disability? And what work or task has it been trained to perform? Service animals must also be allowed in most areas unless they pose an infection control risk. A service animal may be removed only under 2 situations. It must be under the control of the patient at all times, whether by tether, leash, or voice. If the service animal becomes out of control and the patient cannot bring it back under control, it may be removed. Out-of-control behaviors include excessive barking or jumping, snarling, growling, biting, and taking a threatening posture that could place the patient and others in danger and or cause harm. The other situation would be if the service animal is not housebroken. You cannot remove a service animal just because of allergies or fear. Healthcare staff are not responsible for the care of a service animal, and failure to comply with these laws can lead to serious legal and financial consequences. Kristi, thank you so much for breaking this all down for us today. And any final thoughts?
Just one, the golden rule in healthcare. Document, document, document. If you ask the 2 questions, document the answers. If a service animal is removed, document why and what actions were taken. If a patient cannot take care of their service animal, document the steps that were taken and the resolution of who will provide care for it, who found the caretaker or boarding or fostering arrangements, and what actions were taken by the staff in this process. Proper documentation can protect both staff and the organization from legal and financial risks. If you ever have doubts, please reach out to the compliance team for guidance.
That's great advice. And if you have more questions, be sure to contact Kristi or the compliance department. That's it for today's episode of Putting the Pieces Together, Healthcare Compliance Simplified. If you found this helpful, don't forget to subscribe to our newsletter, share this episode with your colleagues, and stay tuned for more compliance insights. Until next time, stay informed, stay compliant, and as always, document, document, document.
The preceding program was recorded and produced by the Learning and Development Team at Baptist Medical Center, Jacksonville.